All right, welcome everybody. Thank you for coming. We are pleasantly surprised to see this many people in the room given how beautiful the weather is. And I'm also really relieved to see that no matter how long you've been out of school, you still want to sit in the back of the room. It's just familiar and comfortable, I think, for everybody here. I am excited about the conversation we're about to have. I'm going to introduce all the panelists in a second, but before we start, I just want to let everybody know and encourage everybody to participate in this conversation. I think we'd all like this to be more of a conversation than a presentation, and there are a lot of issues obviously going on in college sports and the sports world more generally. And I know people have a lot of strong opinions about them and want to talk about it. So happy to engage as a group and speak for other panels as well that we'd actually enjoy it more if it's sort of a Q&A discussion conversation. So let me quickly introduce myself. My name is Gabe Feldman. I'm the director of the sports law program here at Tulane. I'm also a law professor. I'm the co-director of the Tulane Center for Sport, which is an interdisciplinary institute at Tulane that brings together sports law, sports medicine, the business school, public health, really all the different disciplines on campus to study sports from a 360-degree perspective. And we are the only school in the world, I believe, I keep saying it, nobody's corrected me on this, we're the only school in the world that has a truly interdisciplinary approach to sports. There are a lot of schools that have a sports management program, sports medicine, sports law, but nobody has brought them all together. And the reason that was able to happen here is because we had one of the best sports law programs in the country. We also had one of the sports medicine programs. So we got together full, and we can now approach problems in the sports industry from a different perspective than most people can, which has led to partnerships with the NFL, Major League Baseball, the NBA, the NCAA. So it's been a really great, I think, innovation and example of the interdisciplinary things we can do and trying to do here at Tulane. So I'll turn it over to Sharby to introduce yourself.
Yes, can everybody hear me?
Yes.
Awesome. So I'm Greer. I serve as the Deputy Athletic Director for Student Services and Senior Woman Administrator here at Tulane. That essentially means my role is the student athlete experience as a whole. So I oversee academic support services, the life skills, kind of career development type programming, and then all of our sport performance units. So athletic training, strength conditioning, nutrition, mental health, those areas that really directly impact the student athlete experience are sort of my bread and butter. Day to day, I also serve as sport administrator for some of our sports. So I supervise our men's basketball, women's basketball, volleyball, swimming, and diving teams. And then in addition, a lot of our gender equity type work across the university, and I liaise with the Title IX office on campus. In addition to that, my work as a senior woman administrator is a lot of responsibility with the American Athletic Conference office. SWA supervise the Olympic sports in our conference, and so a lot of the administrative responsibilities fall on that group as well. So I'm just happy to be here and happy to answer questions that you all have.
Thanks, Sharby. And then we have Damika Fields with us. Damika is actually in the room next door. We just couldn't fit a third chair at this table. So she's zooming in from home, although she's on her way to reunion tonight. So Damika, why don't you go ahead and introduce yourself?
Yes, can everyone hear me? Okay, perfect. Good morning, well, good afternoon. Damika Fields. I do wish I was there. We got our first snow in Minnesota last night, so I cannot wait to get on a plane to New Orleans. I currently serve as sports counsel for New Balance, and what that entails, I mean, I basically do it all, and I'm our only sports counsel, and so I do our individual athlete agreements, our team agreements with different leagues. Also, I do our league agreements, which we have some of those as well. And then if we have team sports on the high school and junior high level, I will work with those, as well as with our Warrior and Brine brands, which are lacrosse and hockey focused. For women is Brine, and then for Warrior it's men focused. So it is a little bit all over the place. And so I'm excited to participate today. I wish I was there in person, but I think this will be really interesting because this is my day-to-day life right now. And it's causing me a little stress and a little heartache and working with so many different schools on this. So it really is a real-time issue for me. So I'm excited to engage with all of you.
Thanks, Tamika. Thank you for joining us. So I thought I'd start us off with a little overview of what's happening in college sports, and then turn to Sharvie and Tamika to talk about what's happening in the day-to-day and what these sort of big picture changes mean in college sports, what it means from the brand perspective. And then we can open it up to discussion about what it means more broadly for the future of college sports and what we can expect next. So I'm going to try to be very brief with the recap of the events that have happened in the last couple of years. The problem is there have been so many events that have happened in the last couple of years, it's hard to be brief. But let me start by saying that there have been, I think, maybe 6 or 7 or 8 inflection points in the history of college sports. And I'd say one was the introduction of the athletic scholarship. So for a very long time, college athletes were not allowed to get athletic scholarships because that violated the amateurism rules. Once those were introduced, that fundamentally changed what college sports were about. Number 2 was the racial integration of college sports. Number 3 was gender integration of college sports and the introduction of passage of Title IX, 50th anniversary of Title IX next week. And then 4 was the Board of Regents decision by the Supreme Court, which essentially allowed the individual schools and conferences to control the television rights for football games, which has led to, in 1981, when there were about 24 games total televised in an entire college football season, to today where there are 24 games on TV from noon until 3. And fundamentally changed pretty much everything about college sports because of that decision. That's number 4. Number 5 is probably the ability for college athletes to make money off of their name, image, and likeness. And number 6 is probably the Supreme Court decision in the Alston case that held that a number of NCAA rules violated antitrust, and that the NCAA is subject to antitrust law just like any other industry in the country. So if those are the 6 over the last 100 years, 2 of them have happened in the last 4 months. And on top of that, we have had at least 7 bills introduced in Congress that would apply to college sports and potentially change the rules of college sports. We have another antitrust suit ongoing right now. We've had concussion litigation that has been ongoing. We had that small COVID issue ongoing and how schools had to deal with that. We've had a massive explosion in television revenues, in coaching salaries. And what has happened, and we saw this in the Supreme Court decision, is that Supreme Court justices are taking a slightly or maybe fundamentally different view of what college athletics are about. Because if you listen to or read the oral arguments, every single one of the justices, from the most conservative to the most liberal, all said something seems wrong with college sports. It seems wrong that there are billions of dollars flowing in. Coaches are getting it, administrators are getting it, facilities are getting it, everybody. But the athletes are getting lots of benefits. I'm sure we can talk about all the benefits that they're getting, but those benefits and no one else's benefits are kept. And the cap on the benefits particularly harms football and men's and women's basketball players who are disproportionately Black compared to the rest of the student athlete population and the rest of the student population. And so it is now being seen as a civil rights issue, commercial rights issue, a right of publicity issue, health and safety issue. And there are people at the federal level and Congress, people at the state level that see it as one or more of those issues, but they're all converging on college sports right now. And you might say, well, who cares what Congress thinks because Congress can't get anything done, and Congress is so wildly unpopular. But what's interesting is the only body that we've seen that is more unpopular than Congress right now is the NCAA. The only thing more unifying than the dislike of Congress is the dislike of the NCAA. But ironically or interestingly, at the same time, people still love college sports. People want college sports to thrive. They want it to exist. They love lots of different things about it. We can talk about why people love it so much. And judges and senators and representatives are afraid of destroying them. And we see that in court decisions. We see that all across the board in discussions at the legislative level. So we're at this point now where people realize there's something wrong with the system, that college athletes are entitled to more benefits. But we're worried that if we give them too many benefits or open the system up too much, that might destroy all of college sports and then limit the benefits or eliminate the benefits for college athletes. And there's lots of aspects of that we can get into. But just to quickly sum up on the legal sides, for those of you who have not been following the name image of likeness, in 2019, California passed the Fair Pay to Play Act, which is not about pay to play, but it allowed college athletes in California to receive money for their name image of likeness. And then that set off a snowball effect where almost half of the states in the country have passed NIL laws that allow college athletes to make money for their name image of likeness. First time this has ever happened. College athletes have been the only group categorically denied the ability to make money off of their name, image, and likeness. And the states decided that was no longer fair. The NCAA was trying to come up with a uniform policy that would apply equally to all states. They could not get that done in time. The first state laws took effect July 1 of this summer. So on June 30th, the NCAA announced an interim policy that said if you were in a state that has an NIL law, your school has to follow that state law. But if you're in a state that does not have an NIL law, it's up to the school to figure out what the NIL policy is. As long as you're not paying the athletes to pay, as long as you're not using these deals as recruiting inducements, and as long as there's a quid pro quo. So it's not just here, athlete, take $10,000. They have to do a social media post, make an appearance, something in return. What we've seen is now a patchwork of not only state laws, but also institutional policies. So a state like Utah, which does not have an NIL law on the books, they thought they were going to be at a disadvantage compared to California and Florida, who do have NIL laws on the books. But now Utah is not limited by any state law. All state laws have some restrictions on what college athletes can do. Utah does not. So what we're seeing in Utah is that schools are getting involved with the deals. And the deals look a lot more like pay for play than NIL deals. And in the state of Colorado, well, they have an NIL law. The NIL law does not restrict particular categories of NIL activity. So there is a sports book, a national sports book that is paying female athletes, Division 1, 2, and 3 in Colorado, to promote their sports book. That is legal under Colorado law. The only reason there was a potential issue is because Colorado's law says that athletes cannot do deals that conflict with institutional sponsors. Colorado University has a sportsbook sponsor. So the fear was that the athlete's sportsbook sponsor would conflict with the school sportsbook sponsor. But the fact that they were going to have a sportsbook sponsor was not a problem. If you had said that to somebody 5 years ago, they would say you're crazy. That would never happen in college sport, that one, schools would be promoting a sportsbook, and two, college athletes would be paid for it. So we're at this point now where we have just, again, inconsistent rules across institutions. And I think most people in college sports believe that we need uniform. That it doesn't make sense that because you happen to be in Utah, you get a competitive advantage versus being in Louisiana or Alabama or Florida, wherever the case may be. So it's a very unsettled area, and right now we're kind of in the Wild West until we get some uniformity, either through Congress or through the NCAA or potentially through litigation. And the last point, in the Alston case, the Supreme Court essentially ruled that the NCAA is not allowed to collectively restrict the benefits related to education that college athletes get. So laptops, musical instruments, science equipment, and then also they're not allowed to limit, at least below a certain amount, cash awards for academic achievement. So now schools are able to offer up to $5,980 per year based on getting a 3.0 GPA or some academic benchmark. The NCAA cannot restrict that. Individual conferences or individual schools are free to restrict that. The SEC has already announced, this may come as a shock, that they're choosing not to restrict that. They've already announced school policies that are being used essentially as recruiting inducements. If you come to University of Arkansas, you get a new laptop, and you also get $6,000 for academic achievement. So that's about 1/100th of the things that have gone on so far in the last 2 years in college sports. But I want to turn it over to Sharvie first and then to Nika to talk specifically about NIL and how the NIL changes have impacted Tulane and other schools in our conference and throughout, because it's easy to talk about the theoretical and the legal aspects of it, but I think it's more interesting to talk about the practical aspects.
Yeah, so thank you for that. Great synopsis. You say it's 1/100. You didn't even mention the Constitution Committee.
That's right. Well, I'd love to see.
On the ground, we've been talking about name, image, and likeness for several years. I'm a former student athlete, and I went to one of these SEC schools, so I know the impact that it could have had on a student athlete's career and experience. So it's been in the discussion about how to pay athletes for a long time. This is a little bit different, right? It's not necessarily paying athletes. They're sort of earning endorsement type deals and having an opportunity to capitalize on their own talents. What we've seen though is there was a lot of hoopla around it and a lot of discussion about how this could be inequitable between genders. What we found though is that a lot of our female student athletes are having an opportunity to capitalize on this, if not equal, or even more than some of our male student athletes. Their branding, particularly on social media, is at a much higher level. They have a lot more attention to detail on their social media. They post more, and so they have a little more attraction and ground to make money off of this. But what we focused on the most, not necessarily, how do I go out and get a Nike shoe deal? That's not, particularly at Tulane, that's not necessarily realistic. What we focused on is not only educating around what this name, image, and likeness legislation means at both the NCAA and state level, but how do you learn to brand yourself? How do you become an entrepreneur if that's what you're interested in? How do you build yourself, your worth, and understanding your worth, one. And then really tying in some, and what we call it is ways brand works, and sort of it's a holistic pillar of NIL. And so we tie in some financial literacy around that. So as you start to make money and as you start to build your brand and your wealth, how do you invest in that so that it's sustainable? And then some help in that as well. And particularly if you are using your body to capitalize on your wealth, whether you are endorsing some sort of sport brand or otherwise, how do you stay healthy, fit, and capitalize on you being an athlete? And so that's been a lot of our focus, particularly over the last year. And that's a lot of the questions that we get directly from our student athletes is, you know what, I'm interested in this. I don't know how to build this company. I don't know where to start. And so we do a lot of that education around that. We partnered a lot with folks on campus. We've brought in speakers as well. We've done some panels with Tulane alum and letter winners as well, just to get their brains working, thinking about what this could mean, what this could look like. But Gabe's right. It's not meant to be a recruiting tool, but the SEC does things a little bit differently, and they're gonna go out and talk about the opportunities that you have when you go to one of their schools. And so our coaches are kind of thinking about, all right, so we're not going to use it as a recruiting tool, but how do we prep our student athletes so when the next person comes, they see this is the program that we've created, and this is what they'll learn, and they can use that information to promote themselves.
Great, thank you, Shelby. And D'Amica, do you want to talk about how it's impacted Reebok and from the brand perspective?
Yeah, so from a brand perspective, I will say it didn't rock us, but it opened the door for our marketing people who are, separate from the legal people and think a little bit differently. If you worked in house with marketing people, they think a little bit differently from lawyers. So when they hear NIL, in June, July 1, I'm getting all these emails, our GC's getting all these emails. Oh my gosh, let's sign a bunch of students. And of course, it's pump the brakes. It's not that easy. And having those discussions with, 10 head of sports who really feel like, Nike's gonna do this, or, you know, Puma's going to do this. All these companies are going to do this. We don't want New Balance to be behind. And it's really like, okay, let's stop and let's really think about this. So I think that there's a couple things that I'm dealing with now where we're trying to make sure this is thought through, because the schools we're working with, this is their first time doing it as well, right? So maybe in 10 years, 5 to 10 years, there will be an actual process. They'll have templates set up that they can send us to say, hey, you know, you have to sign this with the school versus what you want to do with the student. But right now, everyone's just flying by the seat of their pants. And so the process internally for the company is taking some time because we're having to work with the school. So also there's two buckets. There's, you know, New Balance doesn't sponsor a lot of colleges. New Balance Warrior Brine doesn't sponsor a lot of colleges, maybe like a Nike and Adidas do. So when you have a sponsorship deal with the school, it's a little different because you already have that exclusivity with the athletes when they're on the court or they're at practice, right? So you can't really tell them what to wear when they're in class and when they're at home and on their social media. But when they're at practice and when they're in official activities, you already have purchased that for millions of dollars. So that's one bucket. But then if you don't have a deal with the school, then a lot of schools have these policies that says you can't interfere with an existing sponsor relationship that they have. So we're dealing with two different buckets. And I'll say for one major school that New Balance does sponsor, I think we signed the deal in May. Of course, this wasn't contemplated in the agreement. It's signed. And so now we're trying to figure out, okay, we want to do an individual sponsorship with your 3 hockey captains. What does that look like? Right? And you may have your marketing person, you know, they say, you know what, I talked to the student, I talked to the director of the sport, they're all good. They just said that just send the deal to them once it's executed. Like, okay, that sounds really simple. Let me just talk with the GC to make sure. And of course, the GC is like, no, that's not how we're doing it. So step one is really finding the right person to talk to, because what we don't want to happen is that we go through all of these steps, we execute an agreement with an athlete, and then once it gets back to the school, they're like, wait, no, you know, you can't do this. This isn't correct. We need some other documentation. So that's one, is for us just figuring out who we need to talk to. I think the second thing is making sure you get approval from the schools. And we have dealt with, maybe we're dealing with 10 schools right now. I'll say 5 have said that, no, you cannot use the school branding in any way, even if you do get a separate license agreement with the school. And the other 5 have said, yes, you can, but you have to go through these different processes, whether it's a 1-page agreement that the school doesn't have. And so it's us, you know, like, okay, we'll send this, you can use it, or whatever. They all have different approval steps. And so, you know, the thing I am preaching to my marketing people is, what is the benefit here? Because it's a lot of work if you're dealing with 10 different schools and dealing with 10 different administrations and 10 different processes. That takes some work. This is not I'm going to let you all know we want to do an NIL deal 3 weeks ahead of time, and we set a production date, you know, at the end of December, and it's December 1. Like, we can tell you that's not going to happen. We need some lead time because we have to figure out what each school says, and that takes time. But then the agreements are also different, right? I think a lot of our agreements with our professional athletes will have to pay to play, and you will get bonuses if you score 10 goals, right? Or you are MVP of the league or something like that. You can't do that anymore. And so what we've heard from schools is that, you know, brands are not even thinking about that. They're just sending these agreements to the athletes, having the athlete sign, and then the athlete will turn it in, and the school will have to come back and say, hey, this is pay for play, right? Like, you can't have these things. We need a new agreement. So I will say there have been a lot of steps that are included when you want these athletes. And we also have to think about, what is the benefit, and is the benefit worth it, right? If we can't use the school's logo in their marks in any of our advertisements or social media, then is there a benefit of just having this athlete? Because we can't use video of them, right? Because the school's not allowing that. We can't use the school's logo, so maybe we can use the general colors, but you have to be very careful. And then you can only use them in their private lives, right? So maybe on the way to class, maybe at home, or if they go to a YMCA court or something, but we can't use them in the actual game. So is there a benefit here that you think is worth it for all the work that all of us are going to have to put into it, and what's the strategy? So I know that sounds like a lot, but I can tell you real time, it is a lot. And it's something that we are figuring out with the schools, and the schools have been great, but it's something you go to them and they're like, hey, we're figuring this out too, so let's figure it out together. But it's taking a lot of time.
Yeah, thank you, Danica. And it's interesting what she's highlighting is that some of the differences in the state law that are particularly significant are some state laws explicitly prohibit schools from allowing the athletes to use the marks and logos in an NIL deal. Some are silent on it, some are permissive, say you can, as long as you get permission, as long as you follow the university's regular procedures. Others have restrictions on conflicting sponsors, some don't. Others have restrictions on institutional involvement. Can the school be involved in setting up the deal? And some don't, which is why Utah does not have any restrictions. So their athletic department set up a deal for first their football players and then for some of their female athletes. And then most states, many states prohibit institutional. So again, what you can do in one state would be either explicitly or likely forbidden in another state, which is why the NCAA believes that uniformity. Sher, just one more point on NIL for you. When Danica talked about the process for her, can you talk about what the process looks like now that there are third parties dealing with your athletes and sometimes agents? That does it run through you, or you're just finding out about it after the deal is done?
So I personally find out about it after the deal is done, but we do have folks in our office that get it on the front end. So we educate our student athletes at the very beginning of the academic year on our process. So we have a form that the student athletes have to submit to our compliance office. They check it for this exact sort of language. What is it that you're trying to do? Who's it with? What are they sort of promising you? And what are you getting in return type form? And then that compliance office is not there to say, no, you can't sign this NIL bill, but really to educate them and then to keep it on file if for some reason, questions rise from NCAA or, Memphis tells us we're doing something wrong. We have documentation to show that our student athletes are following not only institutional policy, but NCAA and state law.
Great. And just the last point on NIL, if you're following this or not following this, the evolution of the deals, what we're starting to see at some of the bigger schools in the A5 conferences are these cooperatives, these collectives, where donors are coming together, setting up a fund, putting money into the fund, and then that fund gets distributed to the athletes for their NIL. And that for their NIL is sort of added on to make sure that it gets approved by the compliance office. But it's hard not to see these as payback. As we will give you this money if you come to this school. And sure, you have to give us some use of your name, image, and likeness to do a social media post, but that's not why they're really giving them the money. And I don't think anyone intended for that to happen when they opened up NIL. They wanted NIL to allow college athletes to have the same rights as every other college student on campus, not for it to become an end around for pay for play. And so we're seeing all sorts of creative versions of it. My favorite one I've seen so far is a barbecue restaurant in Austin as the Burnt Ends Club. And they get together and pool money to pay for NIL tight ends in Texas. So if you're a tight end in Texas, you get a portion of the Burnt Ends fund. And so we're gonna start seeing this at probably most of the schools where they have donors who can afford to do it. And that was part of the fear, is that this would just lead to, there's already an arms race, there's already competitive imbalance, but this would just widen the gap even more. And again, I think everybody recognizes, most people recognize that college athletes should be treated more fairly, should get more protection, but there's a balance. And I don't think right now we're at that balance. And I think the problem is, and Charlie mentioned, so in addition to the other things I mentioned, The NCAA is trying to reform from within, and so they formed a constitutional convention committee, and Troy Dannon, our athletic director, has been an integral part of that. And so they've just redrafted the basic principles of the Constitution, and then each division is going to come up with more specific policies with the hope that they maintain control over the governance of college athletics with all the external threats. And so there's one other external threat I hadn't mentioned yet, and that is the National Labor Relations Board. And the National Labor Relations Board, many of you probably know, has jurisdiction over private employers and protects collective action, protects unions and protects strikes and everything that employees might do together. There's a debate about whether college athletes should be considered employees or not. Northwestern football players made a petition back in 2014 or 15 saying that they were employees. One of the regional directors of the NLRB agreed with them. That was then sort of reversed by the board itself, saying it's just going to be too complicated, so we're going to punt this. Then the guidance from that regional director was put in a memo by the general counsel of the NLRB. That was reversed by the general counsel in the Trump administration, and that was just reversed again by the general counsel in the Biden administration. So very recently, the general counsel issued a memo saying college athletes are employees under the NLRA. Now, the problem with that has been that it only covers private employers. There's only a couple of handfuls of private schools, at least at the Division I level. What will happen to all the public schools? Most of the southern schools are public schools, are controlled by public employment law and labor law, and most of those public laws say that public employees and student athletes in particular cannot form a union. And so you would have this sliver of private schools where their athletes would have employee unionization rights, and then the massive amount of public schools where their athletes would not. And how do you work that together, which is part of why the board punted on this a few years ago. The real leap that the general counsel of the NLRB has made this time is that to get around that public-private distinction, she's going to argue that the conferences and the NCAA are joint employers, that you're not just employed by LSU, you're employed by LSU and the SEC. The reason that is significant is because the SEC is private. And so the NLRA would have jurisdiction over the SEC. And so if the NLRB and the general counsel is right, that means that this could apply to all students at all schools, not just at private schools. If you want to, on my podcast, Between the Lines, podcast about sports and law, I interviewed the general counsel of the NLRB to ask her why she wrote this, what this means in the future of college sports. So I'll say, other people, Jen, they always laugh when I say this, but either, and Austin, looking at you in particular, download the podcast, or even better, just give the podcast 5 stars. Let's, Tamika or Sharvie, if you have other things you want to add, otherwise, I want to turn it over if there are questions. Yeah.
Yeah, Gabe, the model, the funding model, I think is broken for college athletics. You know, I did that football and in some instances basketball generate all revenue and pays for all the schools. And and the push has been, and I would agree that the administrators and facilities and everything else have benefited that the kids have. So, you know, and NIL is a step in the right direction, but I would suspect that there's also pressure. I'm a football player. I bring in all the revenue for, why shouldn't I be paid more than women's hockey? Or so the revenue model today, and the threat is if that starts to happen, then basically all the Olympic sports are going to go away because. And the other, then overriding that is you've got 125 Division I schools, and maybe a handful of them show a positive budget every year. And the subsidies, like $15, $20 million a year per school. Right? I mean, those are kind of the numbers that I remember. So, with that as background, if we would go forward 10 years with all the pressures, and we've also seen separation between Power Fives and the county. That's going to continue to happen. There's segmentation going on. Where do you see the thing in 10 years? I mean, you're with everything going on. Obviously, it's a Wild West right now. But 10 years from now, where do you see it? And where would you see it Tulane?
Yeah, so I think there are a couple of different possible paths. One is that Congress steps in and says, we want to maintain college sports as we've known it for the last 100 years, which means we want to maintain the amateurism model, where the college athletes are not paid to play, but we also want to give them more rights. We want to give them NIL rights, but make them legitimate NIL rights. We want to give them better health and safety protection. We want to give them better insurance coverage. We want to give them guaranteed scholarships. A lot of things that a lot of people say should happen, and some Power 5 schools are provided, but certainly not provided Division I and certainly not Division II, Division III wise. So that could be mandated by Congress, and the exchange would be the NCAA gets an antitrust exemption or a limited antitrust exemption. They get preemption of all these state laws, so they don't have to worry about each state having their own NIL laws or other laws. And then in return, they promise to give these additional benefits, and that it's more strictly regulated. Perhaps they set up the federal commission to oversee college sports. Perhaps it looks like the USOC model, where there is a federal law that dictates what they can and can't do. That's what's being talked about in Congress right now, and there's a debate. This may surprise you, between the right and the left over what the appropriate solution is. There's the College Athlete Bill of Rights that was put forward by Senators Booker and Blumenthal that would give college athletes all of those rights and a share of revenue generated by the schools if it's over a certain amount. And on the other side, there was Senator Rubio who introduced a bill that said the NCAA gets to decide what they want to do, and they're exempting the antitrust law, and they preempt it. And now they're trying to find a compromise in the bill. And I think if we do get congressional action, that's the most realistic path to maintaining some semblance of the system we have now. Because if that doesn't happen, Congress doesn't step in, I think the other potential path is the antitrust litigation that is ongoing continues, and it continues to be successful, and the courts continue to give less deference to the NCAA, and they make them operate like every other industry where they just have to compete. And they don't get to cooperate on compensation or anything else. One other variation of the congressional model would be cost containment. And the cost containment, the problem with the cost containment argument right now is that the cost containment is only on the athletes. And if we're worried about where they're going to find the money to support Olympic sports, I have one place you can look: the $533 million in debt money that is being used to pay coaches who have been fired. $533 million are being paid because of severance pay for coaches who have been fired. And then on top of the salaries, they're paying the coaches to actually. Let's get cost containment around coaches. Now, everybody says, but they lost that attempt to do that in the law case back in the 90s. I don't think that's true. They did lose that case, but I don't think it prevents them from having some broader cost containment. But the problem is when it's selectively enforced on the athletes. So I think Congress could provide that protection through an antitrust exemption. And if they don't, I think eventually, whether it's antitrust law, whether it's individual states, whether it's the NLRB, they're going to break up college sports and have it be more like the professional model, where it's surely profit-based. And I think what most people want is to try to push it back more towards the academic model. We're never going to eliminate the commercial aspects of it, but can we reorient things so that the priorities are actually academics? And I think there's two reasons we need to do that. One is because it's the right thing to do. That's why we have college sports to begin with. But two is if we don't, the Supreme Court is not going to give any deference to the NCAA. The NLRB is not going to give any deference to the NCAA. If you can point to an athlete that is not able to take a certain class or a certain major because they have to go to practice, the courts are going to say they're not student athletes. They're athlete students. And if they're athlete students, we're going to treat them like athlete students. We want them to be student athletes, prioritize academics first. That would require a fundamental shift in the way coaches and athletic directors and donors act. And it may be that we split where there's the Division IV, the sort of professional college model, where the Power 5 splits and they have their pay what you want to whoever you want. And now you have the rest of college sports where there are rules. I think a lot is now out of the hands of the NCAA because they waited so long. And now that it's more in the hands of the courts and the NLRB and potentially Congress. And that's not a great place for any business to be if you're relying on antitrust litigation, federal legislation, or state legislation. or the whim of a shifting National Labor Relations Board that changes every time there's a change in administration. So how's that for a non-answer?
So I kind of have a three-part question. We'll try to take up all the time here. But the first question I have is if there's any evidence that there's particular states or programs that are becoming more attractive to students. Because like you mentioned, for example, a state like Utah doesn't enact legislation that actually gives them more flexibility with what they do with their NIL deals versus a state that does enact legislation and puts restrictions on it. So is there any evidence that there's particular programs or states where students are gravitating towards because of that environment? Second question is, who are these NIL entities? Are the students typically entering into agreements like directly with Nike, or are these NIL groups more like agents that funnel a variety of different sponsorship deals to that particular student athlete? And then the third question I have is, how are these deals structured to like protect the NIL offerer? Because I know you have situations where like you have a Spencer Rattler at Oklahoma who's a preseason candidate for the Heisman, and he gets benched a couple games into the season. So, if the NIL was a bunch of money up front, can they claw back that money, or how is that structured? So those are my questions that are, again, monopolizable discussion, but those are just kind of things that come through my head.
Sharpen, do you want to handle the first, do I want any of all three of them? Take a first crack at them?
Well, the first one, I think we'll see something that we saw similar to when the cost of attendance was enacted several years ago. So right now, I've not seen any sort of public decision, I'm going to choose this institution over another because of the United States that they've made. It may have happened, but I've not seen it publicly. But I know sort of anecdotally from our coaches on the recruiting trail that cost of attendance has been sort of a sticking point for some of our potential student athletes, where if you go to this institution, your cost of attendance sort of over and above the tuition fees for board books. There's this lump sum of money that you receive if you go here, because that's the way the institution has calculated their cost of attendance versus going to this. So I think as potential student athletes become educated around NIL, I think you may see that shift in terms of decisioning on their choice of institution, but I've not seen it just yet.
And Tamika, do you want to talk about sort of from the brand perspective, who's doing the deals that you've seen with the athletes?
Yeah, so from our perspective, we are working directly with the athlete. The athlete can, of course, like hire an attorney, and then it'll be an attorney to attorney conversation. But so far, I've only been dealing with athletes. I haven't run into any groups, and I know some of these schools do have. I think you mentioned Tulane might have one where it's a education program or a third party that comes in that will help to educate the students. But from my standpoint, I don't know if those third parties are educating and helping to broker deals, or they're just educating. I haven't had to deal with any third parties, and I don't see us having to in the next few months, at least in the sports that we're dealing with. And I will say with the contracts, they are not structured like I would like them to when I think of like an NBA player, right? If you're not playing, we're not paying you. That is not how these deals are structured, right? These deals, really the benefit is the students, not just their social media presence, but it really is like, what do they bring outside of the game? Because if we don't sponsor the school, we really can't get them on the court or on the ice. And so if they do get injured, whatever we're giving, we're going to get. But what I will say is brands are probably not going to be paying the bigger brands, like a footwear brand, like maybe the barbecue brands and, these smaller brands that aren't in footwear, activewear. But I think the footwear, activewear contingent, I don't know if the money will be a big thing. It may be gear, right? It may be value in kind, because that is something to think about. If you do get injured, you can't do the pay for play, right? So you can't say you didn't play half the season, we're not going to pay you or give us back. It really is, we have to pay you no matter what. So hopefully, even if you're hurt, these students now, right, a lot of their value is they're still getting on social media, they're doing these lives, TikToks, Twitters, whatever is out there, right? They still have a lot of importance and a lot of influence. And then you'll see a lot of these YouTube series where it's like, I got hurt, but I'm getting back to what I was, and follow me here. And there's a lot of value in that. So I will say, for us, all of our deals are not just cash, and they're not thousands of dollars, hundreds of thousands of dollars, but it's what's important to the student is a gear. What are some other valuable things we can give in exchange?
Yeah, it's a great question. Just to add on to that, I think it was 3 of the top quarterback, the Heisman candidates at the beginning of the year have either been hurt or benched, and they had big NIL deals or relatively big NIL deals. And I think that's eventually going to get baked into the price that they're willing to pay, because they recognize there is greater risk. And in terms of one of the NCAA rules, one of the 2 rules is that you can't condition payment on athletic achievement. So you can't say if you score a touchdown next game, you get an extra $1,000. But if the player scores a touchdown in the game the next week, you can pay them because they scored a touchdown. So I think we may see more of that, where the sort of staggered a little bit more. The timing is different. And then the last thing is to protect against a Spencer Rattler or the next player who gets hurt. We are seeing more group licensing deals, more along the pro model. So rather than doing the deal just with the quarterback, do a deal with the entire Alabama football team. That's a lot more expensive, but it's also a lot more valuable. Or you can do it with all the quarterbacks, so you don't have to worry if one gets hurt and you've got all of them. And a lot of agencies and lawyers are trying to become the group licensing arm for college athletes, because it's a massive business in pro sports, and it will be a massive business in college sports once it sort of fully evolves. Because the thing that more people in this country seem to care about, the thing they care most about with NIL is getting the college football video game back. And the college football video game can come back if the athletes can be paid for their NIL, if they can wear the logos of their schools, and if you can get that group license. And so somebody is going to be there to represent all of the athletes and get the payday that the Players Associations get the code. So there's a lot of jockeying for position there. And then just the last that thing is not only protecting the offeror, the third party, but it also issue who's protecting the athletes, because now the athletes are not only dealing with agents, and a lot of these are unsophisticated agents who are new to this market, but they're also dealing directly with the third parties, because most of the deals are too small for an agent to be involved. The agent is not negotiating that burn ends deal between the tight ends because they don't want to get 8% of a rack of ribs. Right? That's not worth it for the agent to spend their time doing that. So this is just the athletes directly with the third parties, and there's no oversight of the third parties. If there is oversight of the agents, at least in theory, but none of the third parties.
Thanks.
Yeah, I just wanted to ask at like the student level, what effect is this having on intra-team competition or feelings? Because so much of the college athlete experience is you and your teammates. And once a couple people start getting mega money while others don't, it does become, more like, okay, at professional level, everyone's getting paid, and they all know they're getting paid differently based on their skill, the same way that you and I get paid differently at our jobs. But for students, once money is introduced, what effects are you seeing on the students already in terms of feeling like competitiveness in the team that wasn't there before?
Yeah, it's a good question and a fair question. What we've seen is really because it's so new and they're all figuring it out together, that it's been more collegial than one would think. But I do agree, as money gets introduced, and you think about the football team and your quarterback making when the whole line that's blocking for them, right? Like, there could be some questions around that, but as of now, it's been very supportive of one another and celebratory for one another.
Yeah, we're seeing some athletes, some quarterbacks are saying I'm going to give a percentage of the money I get to my offensive line. It's like Dan Marino got me 600 gloves for his offensive line. But it is an issue. But one thing I think that's overlooked is outside of football and basketball, where there are equivalency sports, where some athletes on the baseball team are on full scholarship and some are walk-ons. That's a big difference at a school like Tulane, and so there are these disparities. But you're right, that's more sort of traditional disparity. This is also a new disparity. I think coaches are afraid of change generally, and this is another potential change that could upset locker room dynamics.
Going back to the students for a second, traditionally, particularly Division I students have one job to be a student, one job to be an athlete. How do you help them then manage a third job, which is to be the entrepreneur, and the pressures that brings?
That is what I do every day. So, I mentioned I oversee some academic support, and that the student athlete experience is everything. And so, having those discussions about prioritizing their time, their energy, and what's their personal values, and where they're going to put their time and energy is what our team does every day. And some will say, I'm here because this is an opportunity to make a better life for not only myself, but my family. So I need to prioritize making money. Some of our student athletes are sending money home to support their families, and so they all have different reasons for why they're doing things. But every day is identifying what those motivations are and keeping them focused and trying to maintain that sort of balance between the two.
So I think we're supposed to end at 1:20. This is odd because you've changed, because usually people will be packing up and leaving as soon as it's happy to, but I think we're happy to stay for a couple extra minutes if people have positions. But feel free to leave if you're.
Can I insert one thing, Gabe, before everyone leaves? If you are, I know you would, having seen this, you wish you could have paid to see this play, but we're actually offering to those of you who are lawyers that need it, if you didn't pick one of these up on the way in, it was like some CLE credit for this session. Just grab one of these on your way out and fill it out. Carry on.
Go ahead.
I was attracted and intrigued about your comment about capturing the $530 million for coaches' pay. But enough about LSU. What was more interesting to me was the reference about Olympic sports and Olympic sports going away. With Tulane having historically a great swimming team, rugby teams, and other sports that are on an Olympic track as compared to a commercial track. How is this in the big picture? How is this going to play out? Or how would you predict that playing out?
So I'm curious to hear their interest too, but the numbers about how many schools are profitable and how many are losing, it's difficult to trust the accounting. Not that I think anybody's trying to do anything misleading, but there are no generally accepted accounting standards in college sports. And what we see is if a college athletic department has a budget, they spend that entire thing. They find a way to spend. They are not looking to return revenue to shareholders. They are just trying to win. So they're win maximizing, not profit maximizing, which is why you see coaching salaries as high as they are and facilities spending as high as they are. I think what we need, and it goes to the point that, look, if the football players and basketball players are generating the money, shouldn't they get to keep the money? But we have a redistribution of that wealth. And I do think it's problematic that predominantly Black athletes are subsidizing what we call the country club sports. Why are we asking football and men's basketball players to subsidize golf and lacrosse and swimming and diving? But I think if you think about it in the academic model, we have lots of departments on campus that support other departments on campus because we value all of these departments. And we don't say, English department, you're not making enough money, we're getting rid of our English department. We recognize that what makes us a university is that we are well-rounded, we offer these things. So I think if we value Olympic sports, which most of us value Olympic sports, we need to find as a university a way to support those Olympic sports. The system right now where most of the money flows to football and men's and women's basketball, I think it's problematic for Olympic sports, it's problematic for all athletes. I think if we recalibrate, and if we actually more strictly enforce Title IX, then I think in a lot of ways this can benefit Olympic sports. And there's certainly a way to do this without destroying Olympic sports. I think destroying Olympic sports, destroying women's sports is often used as the straw man to say, well, we can't change the system. I think if we change the system to control spending in football and men's and women's basketball, we're gonna have a lot of money left over for Olympic sports. And if you look at D2 and D3 schools that don't have football, they manage to have Olympic sports. How are they doing? They're not making money off of football. Now, some of them are doing it with student fees, and we don't want to increase student fees, but there are better ways to control the budget to allow for Olympic sports. But I don't think it's fair to rely on men's and women's basketball players alone to subsidize. I think there are many ways to do it. And NIL, the beauty of NIL is should be that it's not going to affect Olympic sports. That this is not revenue that's being taken from the school. There may be some displacement, some donors who would give to the school, but instead are going to give to the athletes, but we haven't really seen that in a significant way. So this gives an opportunity to the swimmer, to the golfer, to get an NIL deal. Whereas they were restricted in terms of the facilities they had, the amenities they had, the scholarship they may have had. Now they're getting more. Now Katie Ledecky can actually go to stay in college, and the gymnasts can stay in college. So I see it as a way to benefit Olympic sports if done well. If done poorly, then I think, yeah, it could lead to the elimination of Olympic sports. And I wonder if you ask, not to pick on LSU again, but if you asked LSU, put aside their gymnastic programs and some of their other programs, if you could just have football and 3 or 4 other sports and not have to worry about those other Olympic sports, would you do that? I think some of them would say yes. We just want 3 or 4 sports, but we're required to have the other ones to be in Division I. And I don't know what the answer to that is when so much pressure is put on spending and succeeding in football.
I know you mentioned health as being one of the overall issues that you address in your department. With all the education that's coming out about mental health, have you seen the need for that to be included?
Yeah, thank you for that. So yes, a few years ago, actually, we Gabe talked about the Center for Sport and his partnership with Dr. Gregory Stewart and the School of Medicine here. So we, under Dr. Stewart's guidance, used a doctor of social work to begin a behavioral health program just a few years ago. And what we found was, as we introduced the resource into our department, the use was very evident that we needed support in that area. So we've actually expanded our behavioral health department to have 2 clinicians and a case manager to support our athletic department. And that trend is not unique to Tulane.
No.
It is a growing field across college athletics, and I know even at our university, our counseling and psychological services with CAPS on campus is always booked. I mean, one of the reasons we began sort of an in-house program is because it was taking 2 to 3 months just to get an appointment in CAPS, and so we wanted to provide the service more of it and have the service more readily available for our student athletes. And so, absolutely, this is a piece of it. We also do a program for our exiting seniors that includes a senior transition that has a mental health component that really focuses on athletic identity and reconciling that. You've been an athlete all of your life, and maybe you're not going to pick professionally, so what's next and how do you make that a seamless transition out of the day-to-day of the athletic world?
I think it's fair to say from the law school, the university to the athletic department, mental health is, if not the #1 priority, it's in the top 3. I mean, there's just a tremendous focus because there's just been so many mental health issues, not just in college athletics, but as a recognition that within college athletics, with NIL, with the legalization of sports gambling, there might be a lot more pressure on these athletes because the abuse they take on social media now, think about if you then have money on those athletes and someone drops a pass, how they're going to get treated, and then the pressure to get the NIL deal, to keep the NIL deal. So it's, I don't envy the 19 or 20-year-old who has to deal with that on top of also being that.
I've got just a really quick question. Does this, the NIL deals, does that impact a large portion of student athletes, or is it just a small number of student athletes that are even have to deal with this discussion?
So far, it's a small number. I think it's been so widely discussed that folks are sort of figuring out the impact of, what it could be, but as of now, it's a small number of our. I think that's.
Yeah, and I think it depends on the school and the NIL deals that I think I traditionally thought of were the Sprite endorsement deal. Granville does a commercial for Sprite. There are very, very few of those. And I don't think there will be many of those because of the risks that they might get hurt, and all the issues we talked about. But there are going to be a lot of these little deals. Either you get paid to be an influencer, but there are going to be a lot, and we're just not going to know about them. You go to a restaurant, they say, "Hey, can I take your picture for on the wall? I'll give you a free meal." That would have been a violation of the amateurs rules. Now it will be permitted, and likely would not have to be disclosed. So I just don't think we're not going to hear about. Well, now they may take the picture down as soon as they leave, but I think we're going to see we're seeing more of that. So I think a lot of athletes are getting a little bit of benefit, but very few athletes are getting the massive dollars.
Is there anything in place that's stopping, you're a super wealthy booster, there's a 5-star quarterback, and I want to give you $10 million to come to my car dealership once a quarter for 3 years. Is there anything stopping that right now?
So in theory, yes. In theory, that would be seen as a recruiting inducement or pay-for-play. And although the NCAA didn't put in the specific language that they originally had in the more detailed policy, there are states that require it to meet some fair market value threshold. The challenge is figuring out what the fair market value is in a market that's never existed before. But I think if it's that extreme, it's likely they would say that's not a legitimate NIL deal. We haven't seen it yet, though. And there have been deals that look like they're more pay-for-play or recruiting inducement than NIL. But the NCAA has taken a mostly hands-off policy because most of this is controlled by state law. And the NCAA has said, we're not going to tell you what state law
And
is.
so if something that kind of on its face looks shady pops up, how do you envision kind of enforcement or unwinding that agreement to happen?
Yeah, I mean, it's a great question. And so some want the deals to be disclosed beforehand. So then you can say, no, you can't do this. Some it's going to have to be that the contracts are essentially voidable, that the athlete can get out of it. But we don't, so I'm working with a group called the Uniform Law Commission that drafted the UCC among other things, and they put together, everybody always leaves when I mention the Uniform Law Commission. But that has drafted a model act on image and likeness that would include disclosure, registration of the third parties, registration of the agent, and a vetting of the deal before it happens. And then if something turns out that's done wrong with the deal, the student can get out of it and keep the money that they were paid. So I think it's going to get to something like that where we're going to have a standard form contract. There's going to be a centralized agency that is handling these, because right now it's up to each individual compliance department or the state. The state's not going to do anything. And the compliance departments, they're looking around and nobody else is doing anything, and it's not clear that anything is violating the law. Who are they to say that that's too much money for your own? It's too much money for your parents. So we're really in a period of almost complete non-enforcement. The one enforcement that the NCAA took, you might have seen, was I think it was the Center for Illinois Basketball, men's basketball, and he was suspended for 3 games for his NIL deal. And the reason he was suspended is because he did his NIL deal June 20th, 11 days before it became permissible. And so they punished him for violating the rules, even though everybody now can do it, but they hit him for 3 games. And that's all they're really able to do is say, if you violate one of our amateurism rules, we'll get you, but we're not going to look into the weeds of the NIL deals, which is why it's a bit of a wild west until we get that uniform centralized governance, which makes things very challenging for people who work in athletic.
Are sanctions against the school a potential punishment for a student violating an NIL law?
Not unless the school was involved. Yeah.
Gabe, I'm kind of curious, New Balance. You guys must have a budget for this, and I've talked about industry-wide, how much revenue, I mean, how much is going to be allocated to NIL contracts? Could you give us a sense of if you're a New Balance, do you all have a budget for your NIL contracts that you're anticipating? And from an industry-wide perspective, do you have any sense of how much money we're talking about?
Yeah, so I think right now everyone is waiting for sneaker companies are waiting for someone else to jump, right? Because what's tough about it, I think I mentioned it a little bit before, is that Nike and Adidas and Jordan Brand under Nike manage most of those school deals. And so it's like, how much money are we actually going to put out there for an athlete? We can't really brand them, you know, we don't know if we can have a deal with them because each school is different. So then we really have to go to each school and say, can we use your brands? I know you're a Nike brand, a Nike branded team or school. So how much can we actually even use the UNC colors, right? Can we use the colors, but we can't use the school. So there's not, I can say for New Balance is not doing any deals right now. Warrior and Brine, which is like the hockey lacrosse brand, they're doing some things. And I think that's probably what's going to happen with Nike and Adidas and Reebok. And if you think of those schools, they already have been paying millions of dollars to these institutions to use these on court and at practice and all this footage and all these rights. So are they going to put millions and millions of dollars towards getting the athlete when they're at home and when they're at practice with their friends? Probably not, because they're thinking, why, right? We get them when we really want them, which is on the court in actual play and at practice. So it'll be interesting to see, unless there's just a really huge player that already doesn't fall under their fall under a school that they focus on or that they already have. And if there's someone they really see a benefit of getting their social media presence right, because even if, you know, New Balance sponsors a school, we can't do the one-off commercial with the athlete. Even if we sponsor the school, right, we still would have to do an agreement above and beyond that. But I think right now, the brands are really having to decide what's the benefit of getting that player off the court if we can't use the school brands, if we can't use the marks, if we can't use them in official play. So I'll say for New Balance right now, and for probably other brands, it's like, let's just wait and see who jumps first, and let's just see what that looks like. But we're not going to put too much money into it now, because a lot of our money's already going to these bigger, you know, $10 million, $20 million a year license agreements with these schools where they're already outfitting the whole school in every sport or almost every sport. So it's like they probably are thinking, we've already got this covered to a point. What's the benefit? And so I maybe in the next year, right after the new year, give it a summer, we'll see, okay, if someone jumps. But right now, I wouldn't be surprised if it took a while. I'll say Puma did Mikey Williams because he's in high school, right? So that's a big deal, but he's a high school player. So I don't think there's really exclusivity deals with a lot of these high schools. They're so small unless it's one of the big nationally ranked ones. So it's like, okay, we can get him in, but I'll be interested to see if his deal changes from high school to college, and then how these deals change where we're going to sponsor you while you're in college, because we're thinking through that. But when you go professional, right, the deal changes, the reach changes. So budgets, probably not a lot right now, but that might change in a couple years.
Yeah,
Yes, Charlie, you said that, you know, it's all about social influence right now, right? So I guess the question is, who's going to become the first Kim Kardashian?
Well, there are some out there already. The Catador twins, and there are some with massive social media followers who are not high-profile athletes. But just to follow up on that question, I think the $1 billion pot at the end of the rainbow is if the athletes can do joint deals with the schools, like you see at the pro level. So when I use Reggie Bush, when Reggie Bush was in a Saints jersey doing an ad, he got paid a lot more than it was just Reggie Bush wearing a t-shirt. So think about 2 years ago, if Nike were allowed to use Zion in an ad with his Duke jersey, how much that would have been worth to Nike, and how much they would have been willing to pay for that. And then also how much it would have been worth for Adidas to sign up Zion, so that Nike's paying all this money to be the apparel company for Duke, and yet Zion is Adidas. So that's been part of the fear, is that this would use ambush marketing and the undercut the money that's going to the entire university. We haven't seen that yet, and you can't do the co-deals yet. Yeah.
What do you see on the influence on the coaches, right? So you have these kids that are coming out of high school that are great athletes. They're heading to certain universities. And, you know, are these coaches now going to have to take into account, not only can they academically survive at the school to which they're being recruited, but also can they perform athletically? Are they now having to look at number of tweets and Instagram accounts? Like, does that become part of the discussion in the next couple of years?
It's in the discussion now. I'll tell you. I met with our head men's basketball coaches about this 2 weeks ago. It's very much in the forefront of his mind in trying to ensure that all of our student athletes, particularly on that team, but our student athletes have the opportunity to capitalize on that, on an invitation like this, because of their backgrounds in particular, right? Like he's coaching a group of young African-American men, and he wants to ensure that they are fully taking advantage of all the opportunities that they have in front of them. And so this is very much in the forefront of his mind. And if there's opportunity for him to have a discussion about how they can capitalize on it while he's out recruiting folks, not in a way that's like, come here and we'll get you an NIL deal, but NIL is a thing now, and you can capitalize on your name. Very much a point of focus for him, in addition to all of the.
There's a whiplash because they were so tightly controlled social media accounts of athletes to be careful what they were saying. All these policies in place restricting when they can do it, what they could do. Now they can't do that because they're getting paid to be on there. And now they're getting paid to do podcasts, and they're getting paid to do interviews. So it's a whole new world for all of a sudden you have to worry about what your athlete is going to say and what they're being paid to say. And then again, I don't mean to keep bringing it back to sports gambling, but there are a lot of people who would love to know the health status of the quarterback. And the offensive lineman who's in the locker room with them probably has some information about that. And how do you control what they say when they're in an interview or they're in a podcast? It's just a lot of issues that are, again, that make it like much more difficult for coaches and for journalists. All right, well, I think we've exhausted. Thank you so much for doing this, and look forward to seeing you in person soon.
Thanks, everyone.
Well, good luck with the snow.